Hello, welcome to the channel. My name is Vitaly Kurchin, top firearm rights lawyer in Washington State. In this video, I'm going to talk about protection orders. Protection orders often have implications for firearm rights, so I'm going to bust some common myths about protection orders, explain how they work, what to do about them, and why you absolutely need the representation if you're on the receiving end of one. Stay tuned. Let's start with the different types of protection orders that exist. Before I get into it, a quick note on terminology. The petitioner is the person who files the protection order and seeks protection. The respondent is the person against whom the protection order is filed. A domestic violence protection order is for when the petitioner and the respondent have a family or intimate partner relationship. Family can be established by blood, marriage, adoption, or simply living together as platonic roommates. An intimate partner can be established by a current or former dating relationship, marriage, or having children in common. A sexual assault protection order is for when the petitioner accuses the respondent of sexual assault, but there is no family or intimate partner relationship. This is often used in the case of date rape, where a dating relationship hasn't yet been formed. A stalking protection order is for when the petitioner accuses the respondent of stalking. This is closely related to a domestic violence protection order, but a family or intimate partner relationship is not required. A vulnerable adult protection order is for when the respondent is accused of abandoning, abusing, exploiting, or neglecting a vulnerable person. A vulnerable person is typically one who is of advanced age or developmentally or physically disabled. An extreme risk protection order is for when the respondent poses a significant danger of causing personal injury to self or others. This type of order is meant to disarm the respondent. While the goal of most protection orders is to prevent the respondent from doing some sort of harm to the petitioner, and a restriction on firearms is a collateral consequence of the protection order, the extreme risk protection order is the only protection order where the restriction of firearms is the intended and only consequence. An anti-harassment protection order is for when the petitioner accuses the respondent of harassment, which includes conduct that is alarming, annoying, or is detrimental to the petitioner, or an act or threat of violence. This is typically used when the petitioner and the respondent have no special relationship and is often used in disputes between neighbors. The previous protection orders are all civil in nature and can be filed and issued as standalone cases. There are other types of protection orders that can be issued as part of a different underlying case. For example, in a criminal case, the court can issue a protection order during the pendency of the case or after a conviction is entered. And in a family divorce or parentage case, the court can issue a restraining order or a protection order during the pendency of the case or after the final decree is entered. The burden of proof in the protection order is a preponderance of the evidence. What that means is that the petitioner needs only to prove that when he or she is alleging is only more likely than not to have occurred. Evidence provided is often in the form of text messages, emails, and witness statements. However, and this is an important point because a lot of people get tripped up on it, the petitioner's own testimony is evidence. The fact that the case may be he said, she said does not change the fact that each party's testimony is evidence. Any type of protection order can prohibit the possession of a firearm, and most protection orders do actually prohibit the possession of a firearm. Now, let's look at some common myths, misconceptions, and mistakes about protection orders. The most common one that I see is a person that heads to court by themselves to defend the protection order, thinking that they'll just explain their side of the story to the judge and the judge will dismiss the protection order. This cannot be farther from the truth. If you are served with a protection order, you must take it seriously. All judges have a bias toward the petitioner and toward issuing the protection order. You need to be represented by a skilled and effective lawyer. Protection orders are not to be taken lightly. They should be treated as seriously as a criminal charge. There are many collateral consequences, including the loss of firearm rights. If you attempt to defend yourself, you will lose 9 out of 10 times. Do not wait until after you lose to hire a lawyer because it will be too late. This is a common continuation of the same mistake. Thinking you can handle it on your own and then consulting with a lawyer only after you lose. At that point, it is too late to do anything. The protection order cannot be dropped or modified at that point. Your only chance is to get a representation before your court hearing, not after. The next common myth is that a protection order doesn't prohibit the possession of a firearm if the judge did not check the firearm surrender box on the order. This is not true. A protection order can restrict firearm possession even if the judge did not require a surrender of firearms or check any boxes on the order about firearms. If the terms of the order restrain you from harassing, stalking, threatening, or assaulting the petitioner, the order will prohibit you from possessing firearms. Another common misconception is that a protection order will only prohibit firearm possession if the petitioner and the respondent are intimate partners. In reality, the relationship between the parties does not matter. An order can be firearm prohibitive even if it's between neighbors, so long as the terms of the order restrain you from harassing, stalking, threatening, or assaulting the petitioner. This confusion can stem from the fact that a firearm prohibition under federal law does require an intimate partner relationship. However, the prohibition under Washington state law is much broader and does not require any specific relationship between the parties. Lastly, a common pitfall is the idea that you won't defend the protection order and it will be over in a year and then you can go about your business again. The problem with this thinking is that the petitioner can come back to court in a year and ask for renewal of the protection order. And the double whammy about this is that once the petitioner asks for renewal, the burden of proof shifts from the petitioner to the respondent, and the judge is actually required to grant renewal unless the respondent proves by preponderance of the evidence that he or she will not resume acts that led to the protection order. Thus, the respondent must always remain vigilant about defending protection orders, even on renewal. And if the respondent does not continue defending, a judge might actually grant the petitioner a permanent order, which will be effective for life. So that's protection orders in a nutshell. I hope you found this video helpful, and I hope you understand the importance of treating protection orders seriously. If you find yourself served with a protection order or need an old protection order terminated, feel free to reach out to us. We can assess your situation and provide options on the path forward. Thanks for watching, and I'll see you next time.